challenging jurisdiction to enforce. It's quite difficult, maybe on the ground sometimes to get certain things from registrars and corporate registrars in Russia, but the amount of leaked data out there, it's just a plethora that there is to mine. So in some sense, places like Russia, Iran, Myanmar, there's a lot more data to interrogate, which can help you find assets, but also prove alter ego. We've also made leaps and bounds in terms of satellite imagery, with the effect that hiding certain asset classes, mainly ships, as I mentioned before, it's getting much harder, particularly in the post-Russia, Ukraine
harder to hide or harder to
excuse me, easier to find. The ships are. But what's gotten harder, I think, the CGEU, when they voted to, restrict the openness for the corporate beneficiary laws, that's been something that's made things a lot harder, and that's been quite a changing landscape.
That's interesting. In the Russia situation, I'm wondering if the recent sanctions that a number of countries in North America and Europe have placed on Russia are also making it more difficult. We know, I think Russia has the largest amount outstanding, some 60 billion. It only is third in terms of number of awards outstanding, but the amount is very large. And I'm wondering if the sanctions are making this an even more difficult task.
I guess there's sort of two pieces to it. One is the legal side, and then is the sort of the how do you find it side, and what you're allowed to do. And historically, London had been very much the center of the universe on Russia litigation. A lot of sort of oligarch on oligarch litigation and other related litigation. And from a litigator perspective, it's become more difficult because the requirement of there being licenses to have some of this litigation, either representing sort of Russian affiliated entities, and then if you're on the other side, dealing with the consequences of these sanctioned entities either having licenses or not having licenses, delays the litigation, allows for like another level of defense, and has made, and a lot of law firms have decided not to be involved in this litigation. And I think from a litigator perspective, it's sort of another hurdle you have to get over. I mean, the good news is that the assets might be frozen and easier to get at if you get a judgment. Celeste, you were gonna.
No. Well, yeah. Celeste, do you have anything?
I'm sorry, Celeste. Sorry.
Do you have anything?
Yes, sir.
Thank you. No, particularly about particularly about Russia, I cannot really say much. Russia is not a contracting state to the ICSID convention, and Russia has never been quite involved in an ICSID case, not under the convention, not under the additional facility rules. What I can say, however, about sanctions is that, and also what Stephen was saying, is that they can affect, they can be an additional hurdle to execution proceedings over specific assets. So we saw, for example, that here in the US, execution proceedings for ICSID awards have been halted in certain cases against Venezuela due to domestic sanctions that are imposed by the US Treasury Department's Office of Foreign Assets Control, also known as OFAC. And so what we saw is that the parties need to apply for the licenses, Stephen was saying, to be able to attach a specific asset. But it's important to be clear, this doesn't have to do with whether or not the award is recognized, whether or not the award is enforceable. That's a different issue. But again, it's another layer of, or another hurdle when it comes down to the execution of a specific asset when you would need to get a license.
And I was just going to add quickly on the intelligence side to your point, Steve. Russian aircraft have been effectively banned from the EU and US airspace as a result of sanctions on the sector. That takes immediately one of the more traditional asset classes against which you can enforce just completely out of the equation. And similarly, while I mentioned it's easier to identify vessels, Russia has been quite careful about where they port their vessels. And so it's a similar dynamic in terms of the sanctions affecting the ability to enforce against the vessels, against crude oil. And there are far fewer, in fact, Russian state-owned vessels that are porting in Europe. So that also reduces the enforcement landscape or ability, accordingly. And of course, there are other examples as well. I mean, Russian banks leaving Europe, where previously they had a pretty significant presence.
Yeah, and just a small note on that. Another challenge has been enforcing awards in Russia because, as some of you may know, in mid-2020, Russia implemented some changes to its commercial procedure code, which actually established the exclusive jurisdiction of certain Russian courts over cases where a Russian party is subject to sanctions or where the dispute has arisen out of sanctions. And this actually raised concerns that Russian parties would be able to easily avoid arbitration, saying, "Oh no, I'm sanctioned. I cannot, I cannot go to arbitration." And there's been a few precedents interpreting this commercial code. In May 2021, there seemed to be we were optimistic about the interpretation of the code because the Supreme Court interpreted one of the amended provisions of the code in a restrictive way to mean that arbitration clauses with sanctioned Russian parties are only invalidated when the sanctions render the arbitration clause incapable of being performed. But then later on in July 2024, the Supreme Court took actually a broad interpretation of the amendments to the commercial code. And this is actually an interesting case. I don't know if we have a lot of time. I'll try to sum it up, but basically, this arises from a transaction between a German buyer and a Russian seller. A German buyer initiates London-seated arbitration proceedings. The contract was governed by English law and included an arbitration clause under the rules of the Federation of Oil Seeds and Fats Association, the FOSFA Association, as I said, with a seat in London. And then following Russia's invasions in Ukraine in February 2022, countries like Ukraine, the UK, and Denmark, as you know, imposed restrictive measures on Russia. And in retaliation, Russia issued a decree designating unfriendly countries. And Ukraine was one of the countries listed in the decree, obviously. So then in November 2022, the tribunal rendered an award against the Russian seller, which the German buyer then submitted to the Russian courts for recognition and enforcement. And actually, the Supreme Court in Russia ruled that enforcement of the arbitration award, in that case, violated public policy based on several grounds. And I'll let you read about it, but including one of them being the impartiality of unfriendly state arbitrators, because one of the arbitrators was Ukrainian, was an Ukrainian national. The Supreme Court refused to enforce the award because it was a national of one of the unfriendly jurisdictions listed in Russia's decree. So those are just some of the developments. Of course, it's not news for anyone that it's challenging to enforce awards in Russia nowadays, and sanctions have been a huge component of that challenges.
So the creditor was trying to enforce the award in Russia?
Yeah.
One of the other ongoing works in progress that I think is a challenge is the whole question about EU and intra-EU cases and the position of the EU, that EU law has primacy over international law. And then on the other side, EU states who might say, I'll pay this award, find that they are potentially being charged with state aid. So they can't kind of manage it one way or the other. And I say this is a work in progress because there are a number of cases at different stages. And I recognize it's a sensitive issue for anybody to talk about, but it is something that potentially could affect enforcement in a number of jurisdictions that we've always thought of as very solid citizens in the international stage. So I'm just wondering if anyone has any thoughts on that, or how it unwinds, or it could be a pass as well.
No, it's a good question. From the US perspective, as I mentioned, the next era case is a DC Circuit case that came out this summer that was very complicated because there were injunctions issued by the trial court and there was a recognition of the award by the trial court. And the DC Circuit unanimously recognized the award, again, not using the ICSID convention itself and statute as subject matter jurisdiction, but using the arbitration waiver exception. But the court was split on the enforceability of the injunctions by a 2-to-1 vote. The majority said the injunctions were not enforceable, that prohibited, it was basically an anti-suit injunction, that injunctions had been attempted to prevent the creditor from enforcing the award in the US. this is by no means the end of this, because one, en banc is being sought, and eventually cert will be sought. I don't know if either of those will go anywhere, but it's back down to the district court, because Spain has additional defenses on enforcement that it seeks to raise. Previously to this, the Macula series of cases against Romania, which have been litigated seemingly around the globe, has generally come out in favor of the creditor there, the Macula brothers in DC, and that was affirmed by the DC Circuit. That was before some of the jurisprudence from the EU came out, trying to block the enforcement.
Yeah.
And then maybe others have more expertise on the European side.
Yeah, speaking of Macula v. Romania, in Luxembourg, the court dismissed the enforcement action. That was in July 14, 2022. Right. I'm not sure timing. I think it was before this other recent precedents outside of the EU. But yeah, unsurprisingly, in most of the EU jurisdictions, courts have been reluctant to enforce intra-EU awards. In other jurisdictions outside of the EU, courts have been more willing to enforce awards. So there's been some different outcomes depending on the jurisdiction. And I think that that's an important something to note, because that's why I think, and we're going to talk about it later, but that's why I think a key tip I have for any counsel practicing is to stay up to date with how jurisdictions are dealing with arbitration awards and how friendly they are or unfriendly they are. And speaking of jurisdictions that have enforced intra-EU awards, I think it's the UK, Australia, and the US that they've been.
Another policy that came out fairly recently, which a lot of people thought was quite significant, the Stockholm Chamber, saying when they had to cite an arbitration where the parties hadn't given a preference, their position would be that it would be cited outside of the EU. And a lot of people read into that was a comment on concern about enforceability. I don't know, Celeste, if you have any insight into that, but a lot of people were commenting on it recently.
I'm happy to comment on that. So to give some background on this question, in the last years, the Swedish courts have invalidated 5 SEC awards that had their seats somewhere in Sweden. Now, these awards were issued in investment disputes that were brought either on the basis of an intra-EU VIT or on the basis of the ECT. And the courts invalidated these awards, finding that the arbitrations that were based on intra-EU VITs or on the basis of the ECT, they're incompatible with EU principles and with Swedish public policy. And as a reaction to this development, the SEC earlier last month announced what I would say is a major policy shift, which is that in intra-EU disputes, the SEC board would no longer set Stockholm nor any other city within the EU as the seat of arbitration. And this is a major policy shift because SEC arbitration was synonym with Stockholm arbitration, really. And the SEC board would set Stockholm as the seat if the parties couldn't agree on the arbitral seat. That was the policy. Years ago, that was like 10, 12 years ago, when the SEC began handling the intra-EU investment disputes and the intra-EU objection started to gain some traction. The SEC was concerned that going against its own policy only for the purposes of intra-EU arbitrations might be perceived as compromising SEC's neutrality. Fast forward to present day, after all these developments, I think that changing the policy of the SEC really became a necessity, particularly if you consider that the SEC rules impose the obligation on the SEC to make every effort to issue an enforceable award. You could also view it from a perspective as a business decision, saying, well, we don't want to lose intra-EU arbitrations from our caseload. Now, for purposes of ICSID, as you know, the issue of the seat is of no relevance. ICSID arbitrations are delocalized. There's no arbitration seat. There's no set-aside proceedings before domestic courts. So for an ICSID case, that would really be a non-issue. It's of no relevance.
Perfect. Yeah. No, I thought that was interesting, and people's reactions were swift and
it was
vivid.
A big change.
When you hear about all the lawyering that seems to go into getting an award or a judgment enforced these days, does it make you think that perhaps we ought to be using tools like security for costs or security for awards more often? We have security for costs, as Les can note the new ICSID provision in the new ICSID rules. We rarely see security for awards in investment or commercial, but are these tools we ought to be going to if enforcement is becoming such a legal burden on people?
Yeah, no, I think that that's a very helpful tool. And actually, many attribute the high rate of compliance for ICSID awards to fear of falling out of favor with the World Bank, fear of states to falling out of favor with the World Bank and to access future loans, right? And as you know, the World Bank comprises 5 different institutions. One of them is the Multilateral Investment Guarantee Agency, or MIGA. And MIGA actually provides political risk insurance products governing investors' equity or debt exposure in a project. And political risk insurance, or PRI, can mitigate the risk of investment. So investors could either seek reimbursement of the losses arising from the expropriation, or they could eventually seek an arbitral award, and they could ask for relief in that amount from MIGA if there's a situation of non-compliance. And then, of course, there's other multilateral agencies that can help with award compliance, and one of them is the IMF. I'm happy to talk about it, but maybe you have more comments.
Before we talk about that, we can talk
security
about security for costs. Maybe give the new
Yes.
rule would be
Yeah.
great for everyone.
Thank you. No, I was just gonna say that we haven't really seen an increase of the use of security for costs, not even after the issuance of the new rules. But still, I think it's an important tool that should remain available for any party that may be concerned about the risk of non-recovery if you're litigating against an impecunious party. Now, it's very important to keep in mind that security for costs is an exceptional remedy. Tribunals have viewed a party's proven history of default, such as non-payment of the advance on cost, or if you haven't paid, you haven't complied with an award in a separate proceeding, right? These kinds of defaults, they are evidence of a party's potential inability or unwillingness to comply and have it considered in the context of security for costs. Now, as anything in arbitration, this is a balancing act. And so tribunals also need to think of the impact, if any impact, that it would have on the party that is ordered to post the security. What would be the impact on that party's right access to justice, particularly in circumstances that the party may have become impecunious as a result of the measures that are the subject of the dispute. So what I can say, however, related to security for costs, is that we have seen some use of after the event insurance. That is to insure against the risk of an adverse cost award, which in the context of security for costs has been considered as a factor that reduces the risk of non-payment, and therefore is a consideration for denying an order for security for costs that we have seen. That's good.
And, kind of a first cousin of this has been the increased use of litigation funding. And a lot of times the party against whom relief is sought or is on the other end of the party that's being funded will try to get security for costs because there's some uncertainty in that realm as to whether there is someone who can stand behind an adverse cost order. I think also these have become more prevalent in UK-based arbitrations because the UK arbitrators and lawyers are more typically used to loser pays. And as you know, in the UK court system, those are enforced separately and are, can have very serious contempt sanctions if they're not paid. So I think we've seen more of that in commercial arbitrations that are UK based, where either side, either the respondent or the claimant, can use these to their advantage.
We've got a little bit of time, and I wanted to see if anyone in the audience has questions or follow-up comments. Now is your opportunity. Please go ahead.
Thank you.
If you hit the on button there.
Is that better?
Yeah.
Yeah, well, thank you. Great discussion. I have a question for Mr. Davidson and Mrs. Cuero. When it comes to courts in DC, and most of the conversation has been on domestic statutes and their textualist approach and so on. Do the courts give, is there any temperament to global approaches with respect to other common law jurisdictions? For example, Australia has had a recent trend of being applying deference to sovereign immunity. Do those considerations play a part. And from Madam Quer, the numbers used to look at trends up to 2021. But over the past few years, we've seen a lot of states renegotiate their bits with more reserved approaches. Has that been reflected in their approach to ICSID as well?
Do you want to go first and then?
I can go first, and I can steal a little bit of your first question. And I would say that we have seen that some jurisdictions, particularly jurisdiction Australia and the UK, they have referred to each other in their decisions when considering enforcement of ICSID awards. So there is some cross, how do you say, fertilization there between one jurisdiction, but it's not that common, but we do have seen it. On your question, I mean, it's ICSID contracting states is, it's their sovereign right if they want, to have some restraints. But what specifically do you mean with your question? Like what considerations does ICSID have had? Could you clarify that?
Well, I think it's the general approach. I think what we've seen is states over the past few years renegotiating their bids or updating new ones with more reserved positions. And I think that comes with maybe a new consciousness that this isn't turning out the way we had hoped. And I was wondering if that's reflected with how they deal with ICSID as well, whether it's through formal instruments or whether it's approach-wise.
Yeah, I wouldn't say that for terms of enforcement, that hasn't really affected the fact that the parties are renegotiating their bids. I think it's also a part of our normal development or self-reflection exercise that the states have made after some time when they have seen how the jurisdiction has worked and in which direction the cases are going. They have to make that exercise. So I think that's part of the normal course of international law. And in terms of enforcement, I wouldn't say that has had an impact. No.
I think we had a question in the back. But Steve, if you
Well,
want
just
to
briefly on the U.S. approach to application of foreign law. I mean, it has some weight in this area. That's kind of a hot button question in the U.S. as to how much reliance on foreign law U.S. courts should apply. Here, there's a little less of a hot button issue and more of it can be helpful. I mean, we certainly cite what the rest of the world does, particularly with recognizing ICSID awards as compared to the U.S. approach. So it is of some notion, but there are also the U.S. in some other ways have made things a little more difficult because, like for example, in the New York Convention, the U.S. added a commercial requirement in recognizing awards, and there's this. Again, in the DC circuit this summer, there was a case that turned on that about whether non-ICSID cases that were against sovereigns, could they be enforced under the New York Convention when the U.S. has added a commercial requirement of enforceability of arbitral awards under the New York Convention. And Judge Katz has dissented from a case that recognized an award. The Zhong Shun case, it begins ZHONGSHON. And, cert's being sought in that one too. So there's another area where the U.S. is making things a little more difficult.
I think we had a question here and a question at the end of the table in the back.
Okay, can you hear me? Yeah. Okay.
Yes.
Thank you for a wonderful panel, Meg, and thank you for the hosting by Stepto. My question, or I have two questions. One question related, or mainly for Celeste, related to enforcement of cost awards. I know that some states of member states of the ICSID Convention have in the past complained because of the lack of compliance by some investors who, after losing their cases, haven't complied with the awards. Does the paper provide any useful information as to how to go about that? And that's one question. And the other one, because I might not get a chance, is concerning enforcement of arbitration awards, whether ICSID or non-ICSID. award and the findings or the decisions by jurisdictions both in the US and in the UK and in Australia. One point of reflection is that all of those courts are common law courts, and I have no data for this, but it makes me wonder whether there's any particular comments that anybody in the panel would have concerning the respect of the international rule of law by those jurisdictions as opposed to other jurisdictions. And I don't want to create sort of a suspicion in terms of civil versus common law courts, but it does make me wonder that those courts have indeed ultimately said, well, it might be the mighty EU, but still they have to comply with the international rule of law. And other courts, probably in Europe and members of the EU might not have said the same thing. So those two questions. Thank you.
Thank you. So on your question, the paper briefly mentions the issue of security for cause, and it doesn't really provide any more specific data of how often it has been used or so. So maybe that's an idea for a future paper. But just on a side note, the provision of security for cause was introduced in the new rules, in the 2022 rules, precisely because of what you said, at the insistence of member states that were concerned that they hadn't been able to recover, from cost awards. Now, security for cause was used anyway before the introduction in the 2022 rules. It was really a codification of the practice that existed at that point. And I would say it has saved time and costs so that the parties don't have to re-argue certain things, such as whether or not the tribunal is empowered to issue, what kind of right you're protecting with the security for cost. And as I said earlier, it's not that we have really seen an increase of security for cost, not after the introduction of the provision in the 2022 rules, and not even after, not even considering the numbers that I just expressed, that I just shared with you in terms of enforcement of cost awards.
Celeste, was there a slightly lower recovery rate on costs awards as opposed to damage awards?
Do you mean by recover? I mean, there was certainly a lower rate of voluntary compliance and cost award settlement. So if you compare the damages awards, they had 66% of the damages awards, and versus cost awards that was 31% or 36%.
Okay.
That was 36%. So it was a lower voluntary compliance, and it was also a lower just overall pursuance of enforcement proceedings.
Yeah. Good. All right. Does anyone have thoughts on the other question about the legal tradition and what it says for enforcement? Or do you want to mull on that for a bit? Because that's a big one.
Well, I mean, the results are interesting, which is, as the questioner suggested, the EU member courts are less willing to enforce these awards that arguably run afoul of the EU Charter, and I don't know if it's a civil law, common law distinction versus in Europe, out of Europe. I think.
Yeah, I think it's more in Europe or out of Europe. Not that it's a coincidence that the jurisdictions that had a favorable approach to intra-EU awards have been common law, but I think it's more a distinction in Europe, outside of Europe.
Yeah.
We had one final question at the very back.
Thank you so much for such rich discussions. I have actually two questions. So my first question, and I'm not sure if you guys touched on it, I was curious what rule governs the application of default interest in awards that have been basically delayed for an extended period of time, especially following this vein. I was wondering to what extent the tribunals that issued the final award have the authority to determine the applicable rule or applicable default interest, particularly in some of the cases that you've already stated that they've experienced prolonged delays. So this is the first question. The second one is a bit hypothetical, so I will appreciate any sort of perspectives on it. Do you guys think the introduction of optional post-award mediation as a structured step, right, after an exit award help bypass some of the challenges that you guys presented with respect to enforcing, the award, especially from what I can understand, these enforcers strategically target enforcement-friendly jurisdiction that have robust, enforcement mechanism, and they inadvertently create this sort of form shopping. So do you think that the introduction of this sort of again, post-award mediation prior to whole post-award enforcement would bypass those challenges? Thank you.
Can I jump in on that one? Because I think, we are just at the stage of introducing mediation to investor state, and it's still at the early days. But I think one of the places where it's most likely to succeed is once you have a liability finding, and then it's a question of mediating what the damages are and the method of payment. I think that's one of the main places where you are likely to succeed. And certainly the ICSID mediation rules intentionally said you could have a mediation at any stage. So it's something parties ought to think about, where they've got an award, and do you really want to spend another couple of years with, forensic accountants? And no offense intended, but if you could mediate it out pretty quickly and effectively, there's something for it. The default interest.
Just on that, I mean, I agree with you in principle, but the problem is that the sovereigns that aren't going to pay until they have to pay. And I'm, for more willing parties, I think it could be very useful, especially as you said, Meg, after liability's been determined. On the interest, real quickly, I mean, the most contracts and treaties that are arbitrated don't have a rate of interest. It's usually left out. Some do, some don't. And I think the arbitrators are given pretty wide discretion on setting what the numbers are. In the US, there are special rules that you need to be mindful of. If you turn your arbitral award, especially if it's an international award, so you're in federal court under federal statutes, you turn it into a judgment in a United States court, the interest rate becomes the interest rate as promulgated by US statute, which for a while was not great. In fact, it was zero basically. And now it's a pretty good interest rate because it's all tied to certain Fed rates. Overseas, it's a little different, and it varies by country on whether there's a set national rate or whether the interest rate of the award continues. But in the US, it's very clear. Pre-judgment, the award rate applies. Post-judgment, unless the parties can be said to have agreed specifically to an interest rate, it'll be the default Fed rate.
All right. Unfortunately, we've run out of time, but I would like to thank these tremendous panelists and all of you for being here and participating. Thank you.
Yeah.